Hello everyone, welcome to my channel. This is Cheenu Sharma. So today we are going to talk about foundations of Canadian law. This is very simple exam. So if you are planning to write this exam in April, you can definitely go for it. So in this lecture, I'll be sharing the basic structure, how your answer should be. Then we will also be discussing the syllabus, main points, main areas. I will also have you star mark, highlight important topics from which you will be getting 100% questions in the exam. So this way, I'll be just giving you a glimpse. If you would want to take my course, any notes or any other help with answer writing one-on-one feedback, so you can always reach out to me. So I will be providing you the details of my contact at the end of the video. So do not skip, watch video completely. So this lecture is all about syllabus overview and examination perspective. So before delving deeper into our today's lecture, let me give you a quick overview, a quick glimpse of why and how this NCA Foundations examination is important, and you can say this is backbone or base of more than 60% of the NCA curriculum. So basically, why? Because this subject explains how Canadian law functions in practice, in reality, how we apply it. So, this is more of theoretical structure examination, but when it comes to other subjects which are more practical in nature, for example, let's take constitutional law. So, this is majorly related to constitutional law. You will yourself feel that there are few topics which are completely repetitive. Then administrative law, concepts like judicial review, criminal law. So this NCA foundation subject focuses on power, limits, and legitimacy. That is why we call this as the backbone, the base of NCA curriculum. Now, talking about big picture, you might have also watched my administrative law demo lecture. In that also, I provided you the big picture, what administrative law is, how we apply it, how you have to go about the examination. So here also, before moving further, before moving deeper into the syllabus, let me give you the course objectives, the big picture. So NCA Foundations Law helps you in understanding Canada's legal system, the legal culture, how all legal theories, their core can be applied in Canada. So we know, if I talk about the country from where I come, India, we have three branches of government. Exactly same, we have three branches of government here in Canada. We have legislature who make enact law, then we have executive who implement them in the ground level, then we have judiciary who takes care that the laws, the legislatures that have come into force are properly followed by people, are properly followed by citizens of a nation. So similar concept is in India and similar thing is in Canada. Now, when we talk about foundations, this examination, this subject analyze the relationship between legislature, executive and judiciary. From where Canadian law has come, the sources. Then we talk about reality in today's world, in today's Canadian picture, how we implement the legal theories, how all three branches work together, what is the theory, what are the principles behind that. Also, in this, the one important thing is the indigenous state relationship. So we understand indigenous state legal relationship, then we learn judicial review, statutory interpretation. So this is how your whole syllabus goes about. Now talking about examination structure, what examiners test. So you know all the NCA exams are 100% open book. But specifically, if you talk about NCA foundations, one thing you have to keep in mind is that you might get MCQs, When I took this exam almost 2 years back, so I got fill in the blanks as well, and that was the most trickiest thing. You need to be thorough with the readings. So you might get MCQs, short answers, fill in the blanks, as I just told you, essay form, problem questions. So your focus should be on issue identification, then application of the rules. We follow IRAC format, critical engagement, not memorization. There is no need to cram the sources. Just understand the legal theories, understand the core concepts. You should also be thorough with the meaning, word meanings. Because if you get question, for example, a very short one word answer question, then sometimes, or even in the MCQs, I have seen that sometimes they twist the words. They give you some synonym. You might have read some other word in your notes, in your reading. There you will see a synonym. So no need to panic if you have been thorough with the readings, if you have been thorough with the notes, syllabus, then it will be very easy for you. Also, when I took this exam, so because I got MCQs, fill in the blanks, so almost 40 marks paper was based on this. So I completed my exam in just 2 hours because I knew all the MCQs, I knew all the blanks. So I just had to write 2 3 long questions. So this is interesting also sometimes, because majority of the other exams, they are mostly complete theory. You just have to write, very long answers. But this is kind of, I would say, innovative subject. Next comes core study material. So main is book. So if you want, I can provide you free PDF, but I have it for third edition, but that is also good. Nothing missing in that book. Then, as per the syllabus, whatever cases are mentioned, those cases are more than sufficient. You do not need to go beyond what is provided in the syllabus. You will be getting questions, you will be getting MCQ, short answer blanks, only and only from your syllabus. Scholarly articles that are there, the readings, then supplementary readings, understanding trends, no cramming. Again and again, I am emphasizing on this thing. Now let's talk about the 10 topics that are there in the syllabus. First, we start with basic theories of law and racism. This is the core. If you have to understand any, so this subject, the name is Foundations, Base of Canadian Law. Now, to understand a nation's foundation, a nation's law's foundation, you need to understand what is the thinking behind, who are the researchers behind those laws, those nation building. So for that we have few theories: positivism, natural law, feminist legal theory, critical legal theory, law and economics, racism and systemic bias. So here your main focus should be on understanding law as a social and power based system, how both these things go hand in hand. What is the political influence? What is the social influence? How law has evolved. So for this, you will be doing theories. Number two, indigenous people and the law. You will definitely get direct or indirect question related to this topic. So this is very important. So central and high weight NCA topic, as I have mentioned here: aboriginal rights and titles, self-government, treaties, TRC, UNDRIP. Then we have two important sections, 91, 24, 35. So these will be the topics that you will be covering. Then from where Canadian law has come up. Sources: common law, civil law, what we follow, what our legislature follow while enacting laws, what our parliament follows. So how law is created and applied. Then fundamental constitutional principles. So again, you will be definitely getting question from this topic. So you can star mark these topics side by side in your syllabus. core public law framework, rule of law, equality, federalism, parliamentary sovereignty, constitutional supremacy, separation of powers. Very important, judicial independence. So all these topics. Then parliament and its component. How parliamentary system works in Canada. How our legislative structure is formulated. So monarch, governor general, senate, house of commons. Then what are the functions, where parliament can be made accountable, how it dissolve, prorogation, lawmaking process, bills. So we will be discussing all those things. Then comes executive. So from where executive power comes, the crown prerogative, political execution, judicial limits. Then we'll talk about courts and judiciary. So court structure, how that happens, Supreme Court, High Court, what are the provincial and federal courts in Canada. So because courts are considered as constitutional guardians. When we talk about Indian judiciary system, similar is Canadian thing. So here we call them constitutional rights. In India, we call fundamental rights. So in order to protect that, you will have to go to courts. So they will protect your rights. Then statutory interpretation, very, very important. Again, very high scoring exam area, as I have mentioned here. So what are the approaches to interpretation? What are the principles? Different types of interpretation. What are the rules? Modern principle, purpose, context. So you will be going through all this. Last is constraints on government action. So if government is taking some action and you feel that that is against your constitutional law or that hasn't come up properly through proper channels, so you have always an option of judicial review. So through judiciary, you can get it reviewed. You can question that. So review of administrative action, reasonableness, legality, habeas corpus, AI and governance, how this works. And in today's world, this topic is very important. So post Vavilov, the Vavilov test, which we also deal in administrative law. So similar case, similar concept. Here also we will be discussing. So these are the 10 very simple topics. So again, I would like to emphasize on this thing that take this subject not as a theoretical boring subject, but see this as an innovative creative subject. So this is a sample question that I have prepared for students, and this is how I help students in understanding how you have to write an answer. So let's go through our problem. Government of Pandora is seeking the extradition of Hassan Biat. So first thing, when you read words, try to retain that in your mind side by side whenever you are reading a line, reading a question, because when you see extradition, you know something related to law of a nation has come into picture. That means this word would be important, because what are we studying? We are studying foundations of Canadian law. So our main link is law and foundations, means theory and the law. So try to take out the theories and legal things side by side. Of Hassan Biat, because he is a suspect in a high profile terrorism case, a formal request was made to Canadian government where Hassan Biat currently lives and is a permanent resident. Very simple. Canada has signed and ratified UN Convention Against Torture, which includes an absolute prohibition on extradition of anyone to a country where there are substantial grounds for believing that he or she would be in danger of being subjected to torture. That if extradited, that person may be subject to torture. So until here, what we understand, that our proposition is related to international law. So go straight away to the topic where you have read about this kind of subject matter, like here in chapter 3, sources. Treaty making power, international law, ratified means accepted, means we will have to follow. That is why I told you word meanings are really important. The interpretation is really important for this subject. Like if you don't know what ratified under international law means, then your analysis might be completely different. So Canada's Minister of Justice has confirmed the ruling of an extradition judge that Hassan Biad should be extradited to Pandora despite significant evidence that torture is both widespread and systemic in Pandora and that detainees suspected of involvement in terrorism are particularly at risk. So Minister of Justice who was working under Canadian government has confirmed that this person should be extradited to Pandora although he knew particular person might be at risk. This is completely against the policy which we signed. So big ignorance on part of minister as he or she knows that Hassan might be at risk of torture in Pandora, still sending him. So this is how you have to use your mind while reading a question. This will save your time in the analysis because you already have that picture in your mind. Then it will be very easy for you to just go through your notes quickly, take out rules, take out few case laws and just put those into words under the analysis thing. So let's continue. Although Minister of Justice has discretionary authority pursuant to Canada's Extradition Act not to surrender Hassan Biad for extradition for reasons relating to human rights record of the requesting country or for other humanitarian consideration, Justice Minister refused to exercise this discretion. Drawing from the relevant material in the syllabus, elaborate legal arguments that Mr. Biad's counsel could advance in support of a challenge to Justice Minister's decision. You may assume that counsel is likely to advance an argument based on Charter of Rights and Freedom, but your answer should not include that. So this is important. So you will clearly have to provide analysis only based upon the foundations of Canadian law theories. You cannot include constitutional rights here. So, main issue is, so this is a clear-cut ground in Baker versus Canada case 2, which is also mentioned in the syllabus. Now you are clear till this point that for this answer, firstly go to chapter 3. We have taken out here. Then you have two things to cover: treaty, Baker case. Nothing complicated. One thing that is important to note, no technical things to be included in your answer, only go by facts, reading suggested material as I just told you, no constitutional rights. So we still have to follow IRAC as counsel is involved, legal matter is there. This is not an essay type question asked in how, what format. Usually if questions are in essay format, then you do not need to make it a problem question IRAC format, but this question is straight away a problem question, so you will follow the IRAC format. So this is also important. This also saves your time. Not every question require IRAC format. So issue is, can Mr. Biad's counsel successfully challenge Minister of Justice decision to extradite him to Pandora despite Canada's obligations under international law? Or you can make it simpler, so you can put a question mark here. So until here, your issue is also sufficient. So one issue straight. Now coming to rule. So this is the most important section as taking out rules from question is sometimes tricky. So first is you are following international law, customary law, then Canada's Extradition Act. So the examiner won't be expecting you to know whether this is an actual act or just a hypothetical act in question. So whatever information is there in the question, just stick to that. So only go by whatever is mentioned in the question and syllabus. Next rule is judicial review. Like here I have mentioned in my comment, we took out this rule from question itself. This is how you will have to prepare rules. Because here you won't be getting many sections or such things. So you will have to take out the principle, theories, such rules from the questions itself. Next is precedent. Baker versus Canada, very simple, one case, more than sufficient. So you do not need to put 1,000 cases into your answer. Your answer should be straight. Examiner should feel like, okay, this and this person knows what is expected, is not wasting examiner's time, is not just filling up sheets. So that is not the purpose. Purpose is to check your critical thinking. Now coming to analysis. In order to determine, so try to use good vocabulary words. Try to make a habit of using your issue in the analysis, like to begin the analysis. It should look like you are answering something. So in order to determine whether Biat's counsel can successfully challenge, the court will need to assess whether this and this minister has acted as per Canada's international obligation as per this convention. So you can always use short terms, but at one place you will have to put that in brackets. So the challenge hinges on whether substantial evidence of the risk of torture in Pandora was properly considered, as Canada's legal framework prohibits extradition where there is a significant possibility of torture, a principle rooted both in customary international law and Extradition Act. Since CAT is a customary international law in Canada incorporated to domestic legislation, the prohibition against torture applies directly to Biat's case, as highlighted. Now see, try to use these kind of words. It shows parallel connections. So this is how exactly I used to write answers. So add readings like this. Try not to miss readings in your answer, as these are the main basic things that examiner will be expecting from you to add in your answer. So follow this pattern of reference. It will definitely put a good impression and highlight your reading in your answer. So Canada's approach in treaty making process. So as per that reading, we just have to provide a crux. Then we have to, in that only paragraph, relate it to our current case. So that is important. The relation, the analogous relation side by side is really, really important. So let's read this. So as per this reading, Canada's treaty-making process is a process managed primarily by executive branch which oversees negotiation, signature, ratification, while Parliament plays a significant role in enacting. So how a treaty comes into picture. This structure underscores importance of ensuring that Canada's commitments under international treaties such as CAT are upheld in practice. See, here I have justified the treaty that is in question. Evidence that torture is systemic and widespread, particularly against terrorism suspects, should invoke CAT, which require Canada to refrain from extradition where substantial grounds exist for believing that individual may be tortured. Furthermore, minister's decision to extradite despite compelling evidence could be seen as an unreasonable exercise of discretion. In Baker, now we have used case, the court held that discretion must be exercised in a way that is consistent with humanitarian values and international obligation. You don't need to put the whole case, just those lines which are directly related to your analysis. So the failure of minister, you can see how I am relating everything. I am taking one line from the problem and relating that with the readings, with the cases, and kind of trying to create a storyline here so that examiner can follow the essence, like what you are trying to make examiner understand side by side. So there is a flow, smooth flow that should be going in your answers. The failure of the minister to adequately consider the risk of torture could be challenged on the grounds of procedural fairness. Again, admin law concept, but very basic just to make your answer strong. Moreover, Barnett, this reading points out that the executive branch cannot ratify a treaty until legislative measures are in place to incorporate it into Canadian law. So try to incorporate the material from required reading part related to your question as much as possible. It definitely clearly shows you have understood the concept well. Then this notion aligns. See, I'm making a parallel connection. So use these kind of words. This notion aligns with the reasoning established in Baker versus Canada. So I am relating Barnett with our problem question, then that those two things with Baker versus Canada. So I'm relating everything together. So this is how you make a strong analysis. So according to reasoning in Baker, the minister's decision must be supported by a transparent process that acknowledges all relevant international obligation, humanitarian concern. So again, at last, Council could argue that the UN Convention Against Torture forms part of Canada's binding international obligation. The risk of torture in Pandora makes extraditing Mr. Biad a breach of both international law and Extradition Act provision, which prioritize human rights considerations. So conclusion. Now, conclusion should always be very simple, direct answer to the issue. So in conclusion, Mr. Biad's counsel can successfully challenge the Minister of Justice decision to extradite him to Pandora. So this is how you need to attempt your answer. And this trick is not only important for just foundations. This is how parallel connections, using good vocabulary, using connectors, help you in every NCA exam. So at last, there are some additional suggestions. Always avoid technical jargons, stick to the facts, make your points clear and straightforward. So simplicity over complexity. But everything should go in a flow. IRAC framework wherever required. So only for legal problem question, not for essay type answer. Extract rules from the question, especially for this subject where we have more of theoretical concepts. Basic admin law concepts, you don't need to go by them deeply. Just use them as a vocabulary, add-on thing. Relate facts and reading, as I just showed you. Connect readings. So build connections between different readings concepts to show a deeper understanding. So this was all about today's lecture on foundations of Canadian law. For any guidance or if you are interested in lectures for April 2026 foundations exam, do send me an email on demystifycanadianlaw@gmail.com, or you can always send me a direct message by following Instagram page Jurist Journey. Thank you and have a good day.